Chief Justice John Roberts leaned forward with a smirk, expecting to humiliate her, not to be humbled by her. But when Karoline Leavitt took the floor of the United States Supreme Court, she didn't just hold her ground, she rewrote it. What began as a veiled insult about her background turned into a masterclass that left America's top legal minds speechless. With nothing but a binder, her voice, and the Constitution, she turned a courtroom meant to intimidate into a platform for truth. And by the time the gavel dropped, it wasn't Roberts who had taught a lesson in law, it was Karoline. It was supposed to be routine. Another Supreme Court hearing, another day of procedural language and distant arguments under the grand white dome of American law. But on that cold morning in Washington, D.C., when Karoline Leavitt stepped through the heavy oak doors of the courtroom, time seemed to slow. The echoes of her heels against the marble floor were the first sound to break the hushed murmurs. Every head turned, some faces curious, some skeptical, some outright dismissive. She was younger than most who stood in that room, far too young, some whispered, to argue constitutional law before the most powerful legal minds in America. But what they didn't know, what they were about to learn, is that this wasn't just any appearance, and Karoline wasn't just another name in the docket. She was here for something bigger, bigger than politics, bigger than reputation. She was here for the Constitution, and for every American who felt shut out of their own country's justice system. Just hours earlier, news had broken across the airwaves and social media that Karoline Leavitt, the former White House press secretary under President Trump and one of the most talked about young conservatives in the country, would appear before the Supreme Court to deliver an amicus argument in McAllister v. United States, a landmark case involving civil asset forfeiture and government overreach. Legal analysts snorted. She's not an attorney, some pundits claimed. She's a political media figure, others said. But Karoline didn't flinch. She didn't respond. Because behind closed doors for the past 2 years, she'd been preparing. Night classes, legal journals, phone calls with constitutional scholars, thousands of hours of study. While campaigning across the country, while raising a family, while appearing on national television, Karoline Leavitt had been quietly sharpening her blade, not for clout, not for attention, for justice. Because, like millions of Americans, especially the seniors she met on the road, the veterans in town halls, the churchgoers who whispered their stories after Sunday service, Karoline had heard one phrase repeated again and again. I lost my land. My home was seized. They never even charged me. And those stories, they stuck with her, not just as a public servant, as a daughter, as an American. So she dug in, she found the root. And when she saw what was really happening, the quiet erosion of property rights through unchecked bureaucratic power, she knew she had to act. That's why she was here. When she entered the courtroom, she didn't wear a smug smile. She wore determination. Her tailored suit was navy, conservative, clean. Her blonde hair pulled back, her glasses perched just over a thin folder packed with handwritten notes, originalist briefs, and colonial-era case law printed from the Library of Congress. Every movement was deliberate, every breath calm. This was not a show. This was a reckoning. As she moved past rows of law clerks and dignitaries, a few leaned toward each other. Is she serious? Someone muttered. She's not going to last 5 minutes, another whispered. But Karoline had heard that tone before. She'd heard it when she ran for Congress and was told she was too young. She'd heard it when she stepped up to speak about faith in a room full of cynics. She'd heard it when she stood behind the White House podium and faced down the full force of the press. Every time she heard it, she did the same thing. She stood taller, and she did not waver. That morning, the gallery was packed. Veterans, journalists, high school students on a field trip, retired judges, ordinary citizens who'd driven for hours just to witness what they hoped would be a rare kind of justice. And sitting silently in the back row, clutching a folded American flag in her lap, was Karoline's grandmother, Margaret Leavitt, 86 years old, a retired nurse, and the daughter of a man who lost his farm to eminent domain in the 1950s. She didn't need a sign. She didn't need to clap. She just needed to see her granddaughter standing before 9 black-robed justices speaking for families like theirs. When Karoline stepped to the podium, she didn't clear her throat or glance nervously at the bench. She opened her folder, looked directly at Chief Justice John Roberts, and waited for the signal. The court clerk gave a nod. "Ms. Leavitt, you may proceed." Her first words carried through the room like a bell. "May it please the court." And just like that, the noise faded. The doubt faded, and the weight of the moment set in. She laid out the issue, calmly, clearly. The government's use of administrative forfeiture without conviction, the erosion of due process, the constitutional decay when bureaucrats could seize property from innocent Americans without ever proving a crime. As she spoke, the tension in the room was almost physical. Journalists stopped typing. Justice Gorsuch leaned forward. Justice Kagan crossed her arms, intrigued. And Justice Roberts? He picked up his pen. No one yet knew what was about to happen. But everyone in that room understood one thing. This wasn't just another oral argument. This was history in the making. And the voice making it was Karoline Leavitt's. Chief Justice John Roberts didn't lean back. He leaned forward. And that alone sent a signal through the entire courtroom. This wasn't going to be a polite pass. He clicked his pen twice, glanced briefly at Karoline over the rim of his glasses, and with a half-cocked smile that had unnerved hundreds of attorneys before her, said, "Ms. Leavitt, with all due respect, I find it difficult to believe that someone with your background fully grasps the constitutional implications you're asserting here." There it was. The jab dressed as formality. It didn't make the transcript sound scandalous. But every senior in the room, every viewer at home watching the live stream, every American who had been underestimated in a courtroom or a corporate boardroom felt the sting in that moment. Karoline's posture didn't change. Her breath didn't catch. She didn't even blink faster. She just paused, and that pause wasn't hesitation. It was power. She adjusted the binder in front of her, looked up at Roberts, not with defiance, but with precision, and said, "Chief Justice Roberts, I understand your skepticism. Many people assume my experience disqualifies me from standing here. But respectfully, it's my experience, my background, that demands I do." There was a hush. Then, as if every sentence had been carved with care in the quiet hours of preparation, she continued. "For too long, the people most affected by unchecked administrative power have had no one in this room to speak for them. I come from a place where property isn't just capital. It's memory. It's family. It's the last physical link between generations. And when the government seizes that, without trial, without charge, without due process, it doesn't just break law, it breaks legacy." You could feel the shift. Even Justice Alito, who'd been eyeing his notes, looked up. Roberts narrowed his eyes and leaned forward. "So you're saying the Fifth Amendment prohibits all forms of administrative seizure?" Karoline shook her head gently. "No, Your Honor. I'm saying the Fifth Amendment demands higher scrutiny when administrative seizure is conducted absent a conviction or a clear, direct harm. The founders did not risk life and blood to form a government that could take from the innocent with impunity." She opened her binder and turned to a page with a yellow post-it. "Allow me to quote Madison. Wherever arbitrary power has taken root, it begins by silencing the weak and claiming their property in the name of law." That quote hadn't been cited in this court in over 40 years. Roberts said nothing, but the courtroom felt it. She continued, "With respect, Chief Justice, I believe your own jurisprudence has consistently reinforced the necessity of original meaning in interpreting constitutional text. And if we go back to the original understanding of the Takings Clause, as this court did in Horn v. Department of Agriculture, we are compelled to re-evaluate the permissiveness with which administrative agencies have bypassed traditional courts." She flipped the page. In Horn, the court held that even raisins constituted personal property protected under the Fifth Amendment. How much more, then, does that protection extend to a family's land, home, or business, taken not for public use, but as bureaucratic collateral? A murmur from the back benches. And then Karoline said something that changed the temperature in the room. This court is not just a referee for the elite. It is the final refuge for the unheard. And if the Constitution doesn't apply to the farmer in Nebraska, the widow in rural Georgia, or the retired veteran in West Virginia, then it doesn't apply at all. Roberts cleared his throat. You've come prepared, Ms. Leavitt. Karoline nodded respectfully. I had to. Then she reached down and pulled out a leather-bound folder. In it were hand-copied letters from original framers, taken from the National Archives and annotated by her and two legal historians. Justice Sotomayor leaned in. Are those copies of the Randolph-Lansing correspondences? Karoline smiled. Yes, Your Honor. In particular, their debate over post-Bill of Rights interpretations of federal seizure powers. It's my argument that both express deep discomfort with any action not tied directly to proven criminal conduct. Justice Gorsuch nodded slowly. Then came the voice everyone was waiting for. Justice Thomas. Ms. Leavitt, he said, measured and firm, you seem to be making an originalist argument, one that cuts across the political spectrum. She answered with calm certainty. Yes, Your Honor, because truth isn't partisan, and neither is liberty. For the next 15 minutes, Karoline fielded questions from every justice, liberal and conservative alike. She quoted Lucas, Chicago, B and Q Arco, Austin, and Timms. She referenced cases from colonial-era courts and 19th century state constitutional conventions. She traced a direct line from the takings abuses of King George III to modern civil asset forfeiture schemes. And by the time she closed her binder, even her critics were quiet. Thank you, Ms. Leavitt, Roberts said, his tone softened. He didn't smirk, because in the span of 30 minutes, Karoline Leavitt had gone from an underestimated outsider to a courtroom force of reckoning. Outside the Supreme Court, a crowd had gathered. Veterans, seniors, ordinary Americans. Many of them didn't understand every legal citation, but they knew what they'd seen. A woman who stood alone and didn't flinch. A patriot who made her case, not for herself, but for them. And the smirk that had begun this exchange. It was gone, replaced by silence. And respect. The next round of questions came fast. Karoline hadn't just passed the first test, she had shaken the rhythm of the court, and anyone who knew how these arguments usually went could tell. The justices were now responding to her, not dismissing her. Justice Kavanaugh leaned in next, clearly curious but skeptical. Ms. Leavitt, your argument hinges on the idea that administrative seizures violate due process when they occur without criminal conviction. But modern forfeiture programs are essential tools for law enforcement. What alternative do you propose? Karoline didn't hesitate. With respect, Your Honor, I propose a return to constitutional balance. When a program's convenience begins to erode foundational rights, it's no longer a tool. It becomes a threat. She glanced briefly at her notes, but mostly spoke from memory, her voice calm. The federal government has been seizing property under civil procedures designed to avoid the burden of proof. But the founders made it clear, if you're going to deprive someone of life, liberty, or property, you need due process of law, not a government memo, not an agency letterhead. There was a pause. Then she added more softly, not a knock at the door and a bulldozer waiting outside. Justice Barrett tapped her pen thoughtfully. So you would have us eliminate civil forfeiture entirely? Karoline gave a slight shake of her head. Not eliminate, refocus. Keep it where it belongs, where the government can't get a criminal conviction but has overwhelming evidence. But when it's being used against law-abiding property owners, without charges, that's where the 5th and 14th Amendments demand a higher standard. She flipped a page in her folder. And to answer your next question, Your Honor, we do have historical guidance. I've included a matrix in the appendix of my brief, 27 forfeiture cases between 1789 and 1850. Every single one involved maritime or customs law, not a single land-based seizure of property from an uncharged citizen. That's not an accident. That's original design. The room was so quiet you could hear the rustle of Justice Breyer's robe as he shifted. Justice Kagan interjected. Miss Leavitt, that's an impressive compilation. May I ask, did your team include historians? Karoline looked at her. No, Your Honor, just 2 law students from George Mason and myself. We spent months in the archives. I believe if you want to speak to this court about original meaning, you should be willing to touch the parchment. Even Roberts seemed to appreciate that. And that's when the mood turned. Karoline was no longer on defense. She wasn't just arguing a point. She was teaching. And the justices, men and women who'd seen every kind of attorney, from solicitors general to Harvard deans, were listening. Justice Thomas, who rarely interrupted oral arguments, spoke again. You cited Austin vs. United States and Timms vs. Indiana earlier. Both of those recognize that civil forfeiture can trigger the excessive fines clause. Would you consider your approach an extension of those decisions? Yes, Your Honor, but I'd also say it's a return to form. Those decisions reflect something deeper, that civil forfeiture is not immune from constitutional constraints simply because it's labeled civil. Names don't override rights. Then she looked up at him, not with challenge, but with sincerity. Justice Thomas, you once wrote that our Constitution places limits on the government to preserve the dignity of the individual. That's what this is about. Dignity. Because what dignity does a man have if the state can take everything he owns without proving he did anything wrong? Thomas nodded slowly. The audience, many of them older Americans, retired military, property owners from rural counties, sat motionless. They weren't legal scholars, but they knew what she meant, and they remembered. The farmer whose field was claimed by zoning boards, the veteran whose guns were taken in a civil proceeding he never got to attend, the widow who had to sue to reclaim the title to her own home. Karoline wasn't just arguing precedent. She was speaking for every American who'd ever had their dignity signed away by someone with a pen and a government badge. Roberts leaned forward again. Ms. Leavitt, your brief also makes an argument that the takings clause and the due process clause work in tandem. That's not a common approach. Can you explain? Karoline nodded. Of course, Chief Justice. We tend to treat those clauses separately, as if one protects property and the other protects procedure. But historically, they were seen as two sides of the same shield. If the government is going to take, it must justify the taking and provide fair process before doing so. The founders feared arbitrary seizure because they had lived under it. She paused. They didn't write a constitution to limit the people. They wrote it to limit power. And with that, she closed the folder. She looked at every justice on the bench. And if we allow power to skip process just because it's faster, then we haven't just failed the petitioner, we've failed the republic. No one moved. Justice Roberts didn't say a word, because for once, there was nothing to say. Karoline Leavitt had not only earned her place before the court, she'd made history while she stood there. For the next several minutes, the courtroom transformed. Karoline Leavitt was no longer simply responding to questions. She was leading the conversation, and not by volume, not by dominance, but by clarity, by truth. Even those on the sidelines, staffers, law clerks, press corps, could sense it. Something rare was unfolding. The justices, normally stoic and formal, were actively listening, not just testing, but engaging. Justice Sotomayor raised her voice next, firm but open. Ms. Leavitt, your argument draws a very sharp line between traditional criminal proceedings and administrative authority, but in real life, that line gets blurry. Are you saying the court should force agencies to follow criminal procedure standards in all seizures? Karoline didn't hesitate. I'm saying, Your Honor, that constitutional rights don't blur. The application may evolve, but the protections cannot be contingent on how the government labels its action. She turned a page in her folder. If a homeowner is about to lose everything, the process should be just as rigorous as if they were about to lose their liberty. Because the outcome is the same, the government takes what cannot be replaced. Justice Sotomayor leaned back, considering. That kind of moral clarity doesn't come from textbooks. It comes from lived experience. Karoline continued, her voice steady. America has never feared complexity, Your Honor. We've built an entire legal system on it. What we should fear is a system so efficient, it forgets to be just. That line struck. Even Chief Justice Roberts, whose posture had been skeptical at the start, now sat more upright, not combative, but reflective. Justice Gorsuch jumped in. Ms. Leavitt, do you believe this court has contributed to the erosion of those lines you're now asking us to redraw? Karoline met his gaze. Yes, respectfully I do. Not deliberately. But by tolerating ambiguity in procedural protections under the guise of administrative necessity, the court has, at times, set precedent that favors institutional ease over individual rights. She gestured gently to the bench. And I believe that recognizing that is not weakness, it's wisdom. It's why the framers gave us a court at all, to correct the drift before it becomes doctrine. Justice Jackson nodded slightly. She knew the weight of those words. Every court faces its mirror eventually. At this point, even the energy in the gallery had shifted. You could see it in the posture of those seated. They weren't checking phones. They weren't whispering. They were leaning in, watching this young woman hold her own before the most powerful legal bench in the country. She didn't raise her voice once. She didn't need to. Every sentence had weight, every pause, purpose. Then, for the first time, Chief Justice Roberts returned to the conversation, not as a critic, but as a jurist. "Ms. Leavitt," he said slowly, "your historical references are extensive, but courts must also weigh practical implications. If your framework is adopted, thousands of prior seizures might be challenged. Have you considered the ripple effect?" Karoline took a breath. "I have, Chief Justice, and that ripple is not a threat. It's the Constitution catching up. If past actions violated fundamental rights, they should be scrutinized. That's not chaos. That's accountability." She paused. "Every American, young or old, wealthy or working class, deserves the chance to say, 'What happened to me wasn't right,' and they deserve to be heard." That silence came again, not awkward, reverent. It was the kind of silence that follows truth. And when Karoline glanced briefly toward the back of the courtroom, just for a second, she saw her grandmother sitting tall, proud, still. A single tear rolled down her cheek. That was all Karoline needed to see, because no matter what the final ruling would be, she had done what she came here to do. Remind the nation that the law is not just for the powerful, it's for the people, and it must remember them. When Karoline Leavitt stepped away from the podium, she didn't look back. She didn't need to, because behind her, 9 of the most powerful jurists in America sat quiet, reflective, some still scribbling, some staring, but all of them had heard her. The courtroom, once crackling with anticipation and doubt, had settled into something rare, respect. Even the journalists, those trained to remain detached, paused before moving. Some whispered quietly to one another. That was different. She didn't just argue, she changed the room. As Karoline returned to her seat, her legal advisor leaned in. "You got to them," he whispered. She gave a quiet nod. "No," she said. "The Constitution did." Outside the courthouse, the story was already spreading. Footage from inside the hearing hit social media in real time. Her quote, "The ripple isn't a threat, it's the Constitution catching up," was posted across platforms, overlaid with footage of Americans losing homes, farms, and properties to unjust seizure. By the end of the day, even critics had to admit it. Karoline hadn't just made a strong showing, she had delivered a constitutional moment. In the weeks that followed, op-eds appeared in papers across the country. Some called her a disruptor. Others called her the future of conservative constitutional law, but seniors in retirement homes called her something else. Finally, someone who sees us. A rancher in Wyoming, a former small-town mayor in Alabama, a retired postal worker in Ohio. They wrote letters, posted videos, made calls to their representatives, because for the first time in years, someone had walked into the highest court in the land and made them feel like the Constitution was still theirs. 6 weeks later, the court released its decision in McAllister versus United States. In a 6-3 ruling, they adopted key elements of the very framework Karoline had laid out. The majority opinion referenced her historical research and echoed her language. But the most surprising moment came from Chief Justice Roberts himself. In a footnote that would be quoted for years to come, he wrote, "The court is indebted to the amicus brief and oral argument presented by Ms. Karoline Leavitt, whose historical insight and constitutional clarity reminded us all that legal scholarship is not bound by title, but by truth." That sentence hit harder than any soundbite, and it rewrote more than a case. It rewrote a perception. Because Karoline hadn't come from a silver-lined legal pedigree. She came from the heart of America, from the small towns, from the people who never get invited to the table, but build the table others sit at. And she showed what it looks like when one voice, prepared and principled, stands before power and doesn't blink. So for everyone watching, Everyone who has ever been told they were too young, too plain, too small to challenge the system. Remember this. You don't need permission to speak the truth. You don't need credentials to defend the Constitution. And when the moment comes, whether in a courtroom or a community center, you show up, you speak up, and you never back down. Because the system may not always see you coming, but when it does, it will never forget you. If this story moved you, if you believe in courage, in truth, and in the Constitution, please like this video, subscribe to our channel, and share this with someone who needs to remember what real leadership looks like. Karoline Leavitt didn't just win an argument. She reminded America what justice sounds like when it stands tall. Let's make sure her voice is heard across every courtroom, every town hall, every generation.